Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I have a great topic to talk to you about tonight. It's going to be what is the difference between adjustment and status, and what's the difference between adjustment of status and consular processing. So, adjustment of status is where you can stay in the United States and apply for permanent residence. The benefit of adjustment of status is that you can get a work permit, you can get a travel document, you can stay in the United States with your relatives or with your significant other while you wait for permanent residence. Consular processing is sort of the opposite. Consular processing is where the immigrant family member, the immigrant applicant, the beneficiary of the immigration benefit will need to stay outside of the United States in their home country and complete the process there and come in with what's called an immigrant visa. Once they come into the United States with the immigrant visa, hi there, Jill, and they're processed at the border or at the airport. Once they are successfully processed, they will be able to become permanent residents. Now, there are benefits and there may be some considerations in each case, and it really comes down to your particular circumstances. Hi there, good night, Christine Sukram. It's nice to see you. And so I'm going to go through those considerations. I'm going to explain to you the process, how it works in each case, so that you can understand that if you want to go through adjustment of status or if you want permanent residence, you can decide you can have an idea of which one could work for you. However, keep in mind that this is not personal legal advice. This is general information. You should schedule a consultation to make sure that each process will work for you. Now, the number one thing that you have to keep in mind that I think it leads to a big mistake in the immigration process is that a lot of people think that once they're in the United States and they qualify to apply for permanent residence, they can apply to stay in the United States and apply for the green card while staying in the United States. That is not the case, right? Not everyone who qualifies for permanent residence will be able to get this adjustment of status. You have to make sure you qualify. So it's very important to avoid that mistake and to properly go through the process that fits you legally as well as personally. Now I'm going to take pause to take some questions because remember I'm here to answer your questions as well. And I see here Jewel. Thank you so much for the compliment. That gives me a lot of encouragement. I will continue to show up every night, most nights, to take your questions and also to bring good information. And Jill, I see that you got your interview. Congratulations. I'm always happy to hear this good news. The process of getting the interview is a long one right now. And it can be a frustrating journey for some people. So I'm always glad to hear when you're almost towards the end of your process. So congratulations. And you got back your passport too. So perfect. Awesome. Congrats. And let us know when you are finally complete with the process. You're done with it and it's behind you. All right. So, go ahead, put those questions in the comments because I'm here to answer your questions. Now, in the meantime, while you're thinking of your questions, I'm going to touch on adjustment of status. What does that mean? How can you get your green card through adjustment of status? Will that work for you? And consular processing. Now, only certain individuals are going to qualify to stay in the United States and apply for permanent residence while staying here. And that is going to be individuals who are here, they're already maintaining legal status, They came into the country with permission or they were paroled into the country. And they qualify through some means, either through an employer, through family, through humanitarian means, maybe even through the diversity lottery. If you qualify. Now, at the point that you have entered and you're selected, you would know, and you are maintaining legal status, you could possibly do adjustment of status. Now, another thing is, what if you overstay? What if you are out of status? Can you still qualify for adjustment of status? This is exactly what I help my clients with. One of my most favorite parts of this process is to assist individuals who qualify to get their permanent residence, their work permit in the United States, even though they're out of status. And you'll hear me talk about this very often, talk about ways that you can get status in the United States, even though you may be out of it right now. And so if you want to stay in the United States, apply for your work permit, apply for your green card, apply for your travel document, then that is possible. But you still have to fit specific criteria. Now, you have to be the immediate relative of a U.S. citizen, for one, if you're going to do it through family. Immediate relatives of U.S. citizens are not all the relatives of U.S. citizens. It's going to be the spouse of a U.S. citizen who came in, of course, with a visa and maybe who overstayed. It's going to be the parent of a U.S. citizen, and that U.S. citizen is age 21 or up. That age is very important. You can't adjust status. Your son or daughter would not be able to sponsor you until they're 21 or up. Or you are the son or daughter of a U.S. citizen and you're under 21 and unmarried. So if you fall within this category and you're out of status and your relative wants to apply for you, petition for you, then it is a possibility to go forward, even though your stay expired, you overstayed, or if you were paroled into the country. Now, there are other categories that allow you to stay and apply for status, your work permit, travel document, and then permanent residence. And you don't necessarily need a relative in these cases. Now, VAWA is one that you'll hear me talk about very often. I do assist my clients to get through the VAWA process. That is where where you don't have this relative, you're applying based on mistreatment by certain relatives, but this relative is not involved in your process at all. You get to self-petition on your own. So if you're being mistreated by a U.S. citizen or legal permanent resident spouse, a parent if you're under 21 and unmarried, under 25 in some cases, or if you have a U.S. citizen son or daughter who's 21 and up, they're mistreating you, then this could be for you. Mistreatment is broad, and it really comes down to, are you being subjected to extreme cruelty within your relationship? Are you being abused? It does not require physical abuse. It could, because I say here, abuse is abuse. Physical abuse leaves external traumas and scars, as well as internal, and verbal abuse, mental abuse, emotional abuse, those and extreme cruelty, those do still also leave scars, may not leave external scars, but can definitely cause one to be traumatized. And so this process is for you as well. There's this misconception that it does not include individuals who are being mistreated by certain relatives. It does. So if you're going through this, I help my clients to get this status and then permanent residence. And you can stay here even if you're out of status. And even in this case with VAWA, if you cross the border without permission, then this still may be a process for you. And then there are also other humanitarian ways if you've been the victim of a crime or you've been the victim of trafficking. With crimes, it's going to be a qualifying crime. Any crime that resulted in your physical or mental abuse it can qualify you for the U visa. Common crimes would be assault, it would be robbery, it would be domestic violence, it would be stalking. These are examples of qualifying crimes. And then for trafficking, it does include labor trafficking and sex trafficking. Labor trafficking, for example, if you were induced by fraud, coercion, or force to work, for example, work for someone, to stay working for someone. You were paid little and nothing. You were abused on the job. You were threatened on the job. You were forced to work under conditions that you did not want to work under. This could be a form of trafficking, and you should definitely schedule a consultation for me to evaluate your situation to determine whether you qualify for this. Why I'm talking about this is that the T visa is a way to get status to live and work in the US for 4 years, up to 4 years. And after 3 years of having the T visa, you may be able to qualify for adjustment of status. So while it's not a direct path to adjustment of status, it does eventually can lead to adjustment of status. And so does the U visa. So those are some of the ways that you can stay in the United States and apply for permanent residence. Now, let's talk about consular processing. If you don't qualify for these types of processes, then you'd have to look at consular processing as an option. Now, remember, I know a lot of you may be saying, well, I can't do consular processing. Consular processing, by the way, is where you finish your process outside of the United States. And I know some of you may be thinking you can't do consular processing because you're already stuck in the United States. You're in a rock between a rock and a hard place. You can't stay and you can't leave. What do you do in that case? There is still a way to fix your situation and go on to get consular processing. That's through a waiver process. I do lives on this waiver sometimes. So if you continue to follow me, you go ahead and subscribe, you will eventually come upon a live where I am talking about the I-601 waiver, or if you scroll through my past videos, you'll definitely see where I talk about this. To get this waiver, you'll have to, if you're here in the US and you need a way to fix your situation, to finish up with consular processing because you can't do adjustment of status, that's where you stay in the US and apply for permanent residence, then you'll need to have a US citizen or legal permanent resident, spouse or parent at minimum. Then on top of that, you would have to show that they'll experience extreme hardship if you don't get the green card. My rule of thumb is if you have these qualifying relatives, schedule a consultation. We'll walk through your situation. I'll collect your facts, evaluate your facts, and determine whether this could be a solution for you to still fix your status if you can't qualify to stay in the US. Now, with consular processing though, it's usually where the individual has to be outside of the United States to finish their process for an immigrant visa to come back or come into the United States and then become a permanent resident. Now, with the consular processing, there is no work permit, there is no visa, there's no ability to come and stay in the United States while you wait. You have to wait until you are finally approved for the immigrant visa that allows you to travel to the US and then get permanent residence. So a good way to show you the differences between staying here and applying for the work permit and green card versus doing consular processing where you finish that green card process, the immigrant visa process outside of the United States, is to describe the process. Thanks so much for the roses. I appreciate it. Thanks so much. Now, with the adjustment of status, what happens is first we determine how you qualify for it. So we usually have to file a petition, whether it's through an employer, whether it's through a family member, or some other means like humanitarian means. And we submit along with that, we submit your adjustment of status application, your work permit application, your travel document application. It goes to the USCIS, and from there they process it. They will issue you a biometrics, a fingerprinting appointment to do the background check. Then after that, you usually get your work permit. Then after that, you get your interview. And at that point, you will probably get your decision, or they'll tell you that they need to review further. But your decision is going to come while you're in the United States. With the consular processing, you first have to, your relative or your employer has to file the petition here in the United States. And then once they file the petition, the USCIS, that's the Immigration Service or Immigration Office, will process it, make a decision. If it's an approval, it goes to the National Visa Center. The National Visa Center is like the middleman between the petitioner and the applicant, the immigrant, and the embassy. They collect all the additional paperwork. And then after they receive all the information, they go ahead, schedule an appointment, and pass it on to the embassy. Then you'll have to prepare for your interview at the embassy, attend your interview, and at that point, if you're approved, you get an immigrant visa to travel to the United States. Once you land in the United States, you will become a permanent resident. So that in a nutshell are the differences between the adjustment of status and the consular processing. Now, you have some individuals who would rather do consular processing. If they do have a choice between the two, they would rather do consular processing, because with consular processing, they may have a job that may have commitments in their country, and that may work better. Others, they want to stay with their family. Maybe they don't have a choice but to stay in the United States in order to finish out the process. All right, so I'm going to go through questions because I see some questions coming in. Go ahead. I'm both on YouTube and TikTok, so go ahead, put your questions in. It's been 8 months since I filed and only received a case number. How long does it take for a fiance visa to be approved? So right now it's taking over a year, and it really depends on the embassy and the processing time at the service center and then the embassy. What does card is being produced mean on the I-360? So I don't know where you are in the process, but and Shanoya, I'm not your attorney, so I wouldn't be able to tell you exactly what that means, but it sounds like your card, it could be your employment authorization card, or it could be your permanent residence, if you have reached that point, is being produced, but I don't know which one. That's not a bad thing. If your card is being produced, that usually means that you're going to be getting your immigration benefit. So let's see. What does card is? Okay, so I answered that. Can I travel abroad while my documents is with the USCIS? T-Nati, it depends on where you are. Are you in a foreign country or are you in the United States? If you're in the United States and you're filing for adjustment of status, then you're going to want to get the travel document to be able to leave and come back. If you're in the outside of the United States and you want to visit on a visitor's visa while your paperwork is going through, it's really going to come down to what your situation is. Is it okay to marry him while on J1 program, or it's best to wait until after? So CAB's fund size, you definitely need to make sure you get legal advice. The J1 visa can be tricky, especially if you have the 2-year foreign residency requirement, because once you have that, there are restrictions from adjusting status while you have that restriction. So highly recommend you get legal advice. As a matter of fact, here, remember, I don't answer specific legal questions here. And so if you would like to make sure that you are going about your process correctly, you avoid mistakes, you understand your options and the path you're taking, and you get legal representation, you should schedule the consultation. You can always do that by going to the link in my bio. You can schedule your own consultation, or you can go ahead and call. The scheduling coordinator is available up until 11 p.m. Eastern time. So, if you're married to a U.S. citizen, is it a must to send in their birth certificate? So it's Virgo woman, not necessarily. It may, while the birth certificate is the thing that's gonna, no matter what, everyone usually has a birth certificate. If they don't have their birth certificate, but they have their passport showing that they're a U.S. citizen, then that is acceptable evidence. But I don't know your case, and you, if you are uncertain, that's where you need to make sure you get representation. Can your partner fly out from state to state once they arrive in the U.S.? Now, I don't know your situation or your partner's situation, but generally, traveling from state to state is permissible as long as you're traveling. So you're flying from state to state, you're traveling with the right ID. And you should go ahead, call the airline, make sure you have the valid identification to go on the plane. All right, great questions so far. Keep those questions coming. I'm pretty much finished with the topic that I came to talk about, which is the difference between adjustment of status, that's the process of staying in the United States, and applying for permanent residence. You could get a work permit and a travel document while you wait here. So there are great benefits and advantages to applying for adjustment of status versus consular processing, where you have to or you choose to finish your process in a foreign country, and some people have to do it. They have no choice because there are a limited number of people who can qualify for adjustment of status. That's usually individual, and I went through this list before. It's an extensive list, but the general rule here is: one, you are maintaining legal status in the United States. You have an immigrant visa number available to you at the time that you're applying. And that, of course, you qualify through an employer, through a family member, or through other means to apply for adjustment of status. And then the other is if you are the immediate relative of a U.S. citizen, the spouse of a U.S. citizen, the parent of a U.S. citizen, who is 21 or up, or a son or daughter of a U.S. citizen who is under 21 and unmarried. And then also there's VAWA. If you're being mistreated by a U.S. citizen or legal permanent resident spouse, parent, if you're under 21, under 25 in some cases, or a citizen's son or daughter who's 21 and up, then this could also be a path to stay here. If you have the T visa, the U visa, or you have asylum, those could also be a way. So go ahead and put your questions in the comments. If you're done with your questions, I'm going to head on over to Instagram. So your chance to ask questions is not, you still have an opportunity to ask your questions. Now I'm going to go to The Immigration Attorney on Instagram, same as here, The Immigration Attorney, same as YouTube. It has the same tagline. You can go to Instagram. I will also be on Facebook, and it's the name of the law firm, ST Law Office. You can join me there where we can continue to have this conversation, or you can continue to ask your questions. Thanks so much for the love. I'm going to head out now. I will be back tomorrow at 9 p.m. Eastern Time to answer your questions and also to bring a topic that I think is very important to you. So have a good night. If I don't see you in a minute on Instagram or Facebook at ST Law Office, I hope to see you in a consultation. Also, keep in mind that I do release videos. So I release videos on YouTube and Instagram throughout the day. So those videos give tips, and they highlight the topics mostly of how to stay in the United States and apply for permanent residence, your work permit, while being in the United States. So if you would like to know that information, definitely go to Instagram or YouTube and follow me there, subscribe on YouTube, so you can continue to get information like this. So hopefully I'll talk to you soon. Well, I see one more question. I'm a citizen. Which form can I file to bring my family? So Musa, it's usually the I-130 form, but keep in mind, very important that you get legal advice to fully understand how you need to go about this process. Important for you to get legal representation. Don't underestimate this process because that's the biggest mistake that I see people making right now. So don't underestimate the process. Make sure that you're protected and that you do what is right to ensure you're going about your process correctly. Have a good night, everyone. See you in a minute on Instagram or Facebook at The Immigration Attorney, or I will see you tomorrow or in a consultation. Bye-bye.